Welcome to Divorce Explained, the podcast where we answer your questions and navigate the process of divorce together.
Well, welcome to our viewers. We haven't seen you in a few weeks. We've been busy with other matters and in some cases professional, in some cases personal, but we are back. And today we are going to be discussing something that actually very few people really understand, what parenting coordination or what a parenting coordinator does. So that's what the topic of today will be.
I think it's a great topic.
Thank you. So for the benefit of our viewers, parenting coordination is a post-divorce, post-separation, alternative dispute resolution mechanism. Or to put it in very simple English, once a couple has split up and they've got minor children, generally under the age of 18, it's not uncommon for there to have issues that come up from time to time, and they cannot resolve it themselves. One of the reasons why they split up was because they had differences. They had different viewpoints, possibly pertaining to parenting, that they themselves could not reconcile, which led to them having disagreements, potentially arguments and discrepancies that resulted in that marriage ending. And just because the marriage ends doesn't necessarily mean that the differences of opinion and the conflict as it pertains to children end. And so enter parenting coordination, which is a service that is provided to parents who previously separated, resolved all of their affairs either in a divorce order or a separation agreement or both, and in the separation agreement or the court order, or after that, they've recognized the need for some sort of dispute resolution mechanism. And that is the introduction to parenting coordination. Now, I am a certified specialist in parenting coordination because the Family Dispute Resolution Institute of Ontario has decided to create an accreditation process. That doesn't mean very much. There's a lot of people that are extremely qualified to provide parenting coordination, not the least of which would be Leanne Townsend, if she chose to do such a thing. But in the meantime, we've got one organization in Ontario that is indeed providing certification for PCs, and in fact, I'm one of them. Now, the concept of a PC is something that started actually many, many decades ago in the United States and is only slowly creeping into the Canadian culture, the legal culture here in Canada. British Columbia is head and shoulders above Ontario and, quite frankly, every other province on parenting coordination, to the point where their judges have the power to order that a couple who are going through separation and divorce, and a judge is ordering final orders regarding parenting, a judge can also order that they use a PC, a parenting coordinator, and a judge can put that right into the order. And a lot of people, as a result of that, have come to acknowledge the importance of PCs. And in British Columbia, it's a very common clause to put in a separation agreement so that when issues come up, and they often come up, there will be a method for the couple, the parents, to resolve the dispute without rushing off to lawyers and rushing off to court and asking for judges to make orders under the most emergent and urgent of circumstances. But in Ontario, although PCs do operate here, I'm a fairly busy PC in Ontario, the larger part of the Ontario culture doesn't really even know what PCs do. I've had judges express to me their misunderstanding of the role of a PC. So I'll give you a perfect example. A judge might say to me, as we're arguing over what the parenting schedule should be, a judge in the past has said to me, well, why don't these people just hire a parenting coordinator to figure out the parenting plan? And I say, well, Your Honor, a parenting coordinator does not create a parenting plan. A parenting coordinator helps the spouses implement a pre-existing parenting plan. And for those that want the definition of what a parenting coordinator can and cannot do, I'm going to refer you to two sites. Number one, if you go to the Association of Family and Conciliation Courts parent body in Madison, Wisconsin, there is tremendous information available about parenting coordination on the AFCC website. Again, that's the Association of Family and Conciliation Courts. There is also information on the Ontario chapter of the AFCC, so you can just Google AFCC Ontario. The second place that I would refer you to is a court decision by former, now retired, Justice Cheryl Rogers, who sat in Newmarket, and she published a legal decision in the case called Sehota versus Sehota, Sehota. You can find it by going to www.canlii.org, canlii.org. And she wrote a lengthy decision about the importance and the utility of parenting coordination for couples that have issues. I'll say one more thing, and then I'm going to turn it over to Leanne and ask her, how has she found the use of parenting coordinators? But before I do, I'm going to say one more thing. As a result of the new Divorce Act, there are provisions in the new Divorce Act that came into effect in March of 2021 that specifically said that parents should not be using court as the primary place to bring disputes. They should find a family dispute resolution process outside of court to be able to resolve disputes, which is parenting coordination. Because parenting coordination is where the parenting coordinator, someone like me, uses the following 4 tools to resolve parenting disputes. Tool number 1, education. Educating the parent on what is the proper standard for the purposes of addressing whatever the issue might be, whether it's extracurricular activities, selection of school, camp, vaccinations, relationships with new partners, communication with teachers and doctors and dentists. So number 1, the PC assists parents in learning what is appropriate. Point number 2 is assisting them by mediating the disputes between the two of them. Point number 3 is providing them with neutral evaluation when they have competing views. Oftentimes, they just need to hear from someone if they're thinking right or wrong, and the PC's job is to provide neutral evaluation, objective, rational, and fair-minded information that is child-centric. And lastly, the 4th, and we hope that we never have to use the 4th tool, and that 4th tool is summary secondary arbitration, where when they cannot reach an agreement, the parenting coordinator like me will then allow both sides to make arguments, to provide me with what documents are needed for me to make a proper decision, and then for me to consider the arguments from both sides, and then render what's called an arbitration award, which is the equivalent of a court order. And in fact, it could be converted into a court order under the family law rules. And that way, it allows the parties to speedily, summarily, and objectively be able to move on with their lives and put their disagreements behind them. So that was my very long speech on parenting coordination, and I turn it over to you, Leanne.
First of all, I mean, I think you covered some great information there, so I'm sure that'll be helpful to our listeners. And just in terms of my own practice, I certainly have had a number of clients over the years that have made use of a parenting coordinator, and I think that there's many benefits to it. You know, it's a way to help resolve conflict. It's certainly more cost effective than running to your lawyers every time there's a post-separation or post-settlement or post-court order, you know, parenting dispute, and they're going to come up. I mean, inevitably parenting, you know, especially if your kids are young and you've got many years of parenting and co-parenting ahead of you, there's going to be disputes. Even happily married couples have disputes about how to parent their children, so let alone, you know, divorced couples. So it can be a very cost-effective way for couples to, you know, resolve some of the areas where they disagree. And quite often, it really is a situation of one party just needs to hear what's best, might be best for the children from, you know, an independent person who's got, some expertise in the area. Very often, in a situation where a couple has a long history and they've had a lot of conflict, if as an example, if the mother says certain things about what, in her view is best for the children on a particular issue, dad may not take it seriously coming from mom because of the history and the emotions and whatnot between the parties. But if the parenting coordinator agrees with mom and says, you know what, hey, this decision would be in the children's best interest, then dad would be more liable to take it to heart and come to an agreement where that parenting coordinator has been involved and provided that information. So it can be really effective as a co-parenting tool. One of the, I guess there aren't a lot of disadvantages of it, but one of the disadvantages that could come up is that sometimes you might have a situation where a particular party feels that they don't get along with the parenting coordinator, or they perceive that there's a bias from the parenting coordinator. And again, these are professionals. They're not there to have a bias. They're not, they take their profession very seriously, and I'm sure their reputation very seriously. So they don't want to be known as somebody who has a bias one way or the other. But, sometimes people have personality conflicts. And so, if you have a parenting coordinator and you just do not get along with them and you're constantly rubbing each other the wrong way, that could be a problem, because they, as Steve mentioned, in certain situations, they can have the power to make a decision on a parenting issue. So if you don't get along well with the parenting coordinator, or you feel that there is a bias, real or perceived, then, that can be a problem. So that would be one of the downsides. The other downside, of course, is just cost. Yes, it is more cost effective than, going to your lawyers every time there's a conflict that needs to be sorted out, but there's still a cost involved. And so if you can learn to co-parent effectively as two parents, and you don't need to have another party involved, an independent party involved, or lawyers involved, whatever, that's going to be the most cost-effective solution. But if you're not able to do that, then the parenting coordinator would be the best alternative in terms of cost effectiveness.
And you're 100% right about some of the reasons why PC is not something that we would recommend to everybody. So obviously you don't recommend a PC clause for people that don't have children, or that have children but they're already into their mid to late teens. You might recommend a PC for people with young children, but even for people with young children, they may not have the financial means to be able to afford a PC, and putting that clause into an agreement or order for people that can otherwise afford it might be creating an unhelpful tool, because they're not going to be able to access that tool. Another reason is, people have to understand this, when you sign a PC contract with a PC, they are stuck with that person for the duration of the contract. And just as a side note, I never sign an indefinite PC agreement. My PC agreements always are time limited. Sometimes they're 1 year, sometimes they're 2, sometimes they're 3. Because I don't want anybody to feel that they are bound to me indefinitely, and vice versa. And if you sign a PC agreement without a termination date, a judge might decline to make an order regarding the children if a judge sees that there has been, in an order or an agreement, a PC clause, because then that really means that the Arbitrations Act has now stopped or blocked the person from accessing the court. So be very careful in that regard. If a person doesn't like their PC after 3, 4, 5 months, a year of doing work with them, and there is another year or 2 or 3 left, that could be very difficult for the person who is experiencing a PC that they just don't like listening to or following. And just like in life, we don't get along with everybody. Not every lawyer is made for every client. Not every PC is made for every set of parents. And then lastly, one of the concerns with respect to parenting coordination is people who are just hungry for the fight. And if one person says white, the other person says black, and it doesn't matter. And when you give those people a PC, in effect, what you're doing is you're giving them a regular daily, weekly, and monthly opportunity to engage in warfare. And I've had cases as a PC where if I didn't exist, I'm pretty sure that they would have resolved it on their own. But because of the fact that I'm their PC, everything becomes a fight. The old saying goes, you give a person a hammer, all they see is a nail. And when you give them a PC clause and they broke up because they could not agree on parenting issues, now every issue becomes a PC issue. And it can be expensive, and it can be actually very exhausting for them and for the parenting coordinator. So you got to think long and hard about the application of what a PC can offer and whether it's an appropriate fit for the case. And if in doubt, speak to your lawyer, whether it's Leanne or me or somebody else. Don't ask the PC for advice on whether the PC should be involved, because you do not want to cloud or conflict out the PC, because remember, the PC could stand as an arbitrator in your case, and so therefore you're not really permitted, forget the word really, you're not permitted to have interactions with a PC before there is a PC contract signed, in order to ensure and maintain that sort of neutrality, objectivity, and impartiality.
I see we've had a couple comments from I'm Simply Winters. I think she mentioned that she refers her clients to PCs when dealing with a narcissistic dynamic. That's certainly a case where I agree it can be very helpful. Just I feel that that type of fighting is possible with a party in any divorce, children or not. That's probably true. There's some people who just want to fight for the sake of fighting. I'm curious, Steve, what your thoughts are. We think of a PC as playing a role, where there's a lot of conflict and you have two people who just, can't get along. So it makes a lot of sense to have a PC in the middle of it, helping them navigate co-parenting and potentially deciding things. But with couples who are, somewhat on the same page, not always, but, a little more amicable or able to co-parent a little more effectively. What are your thoughts on whether a PC makes sense, or is it an expense that a couple in that situation doesn't really need?
I believe that every separation agreement and divorce order needs a dispute resolution clause that says, if we have a problem, this is how we resolve it. If you do not include a dispute resolution clause in a separation agreement where they're going to have a future relationship with one another, I think that's a big mistake. The only time there should not be a dispute resolution clause is if it's a childless couple that split up and there's no ongoing support issues, and of course they've resolved everything else. But in the vast majority of cases, there are child support issues, spousal support issues, and parenting issues, and there should be a dispute resolution clause that allow them to find a process that they can end any potential disputes. The disputes themselves might be very, very minimal, but you know what? What's important to you might be unimportant to me, and vice versa. And so there needs to be a way to allow people to at least know that there's a process. So back to your question, Leanne, does everybody need a PC clause? Not necessarily. In some cases, the dispute resolution clause might simply say that they will go to the court-connected mediation service in their community. And in every community in Ontario, we have a mediation service connected to the court where it's partly subsidized by the province of Ontario, and they can access mediators there who, by the way, might be perfectly qualified for those disputes. So there is mediation as an option. There is another clause that we often use when it comes to things like healthcare and education, that the parents will heed to the advice of the child's teacher or doctor. And that way we sort of kick over the recommendation to the independent professional who might have a view on what would be better for the child, as opposed to what the parents believe or otherwise. And in some cases, they do need a PC clause, but you can pare down the PC clause. You could say that anybody that wants to have the PC arbitrated decision, that person has to pay the PC to read, consider, and make a decision. And if the person who asks for the PC to make a decision ultimately prevails in whatever the dispute was, then they could say that the PC will have the power to order that the other parent reimburse the paying parent for the involvement of the PC. And these are ways to equalize, neutralize, and really render more fair the PC clause, particularly for people that might be inclined to pull the trigger quite often. So there's multiple ways to include a dispute resolution clause in an agreement or a court order. And that's, again, something that each person should discuss with their lawyer when they conclude their case.
No, that's great advice. And just for listeners to know as well, generally the parties share the cost of the PC coordinator. And, you know, I think that makes sense because if they're a neutral party, it's important that both sides have some skin in the game financially, and that, you know, there isn't a perception that because one party is paying them, the PC coordinator is going to be more apt to side with them on things because they're the ones, you know, paying for their service. So, you know, generally it is shared, although Steve did outline some situations where that might not be the case. And I wanted to go, I feel like I'm interviewing you a little bit today, Steve, but I wanted to go back to the comments you made at the beginning about how the use of PCs is far more common in British Columbia. And I'm wondering why you think that might be the case. Like, why has it not taken off in Ontario the way that it has out west?
So in many respects, each province has their own government and their own premier and their own bureaucrats, and every government of Ontario, of Canada, is at a different level of progress. And certainly we've seen different provinces go different ways with respect to how they handled COVID and the pandemic and the judicial system. So no different. You've got different leaders with different policies and different practices in each province. When it comes to family justice initiatives, BC, as long as I can remember, a good 30 years now, has always been ahead of the rest of Canada. And kudos to BC. They just happen to be much more innovative and much more ambitious with respect to servicing, separating, and divorcing couples. Now, that's not a bad thing. At least we have one province which serves as the torchbearer for the rest of Canada. And it gives us an opportunity to go, well, look what they're doing over there. Maybe we should do that over here too. And that is exactly what is going on in Ontario. The Ontario leaders are looking at BC's family law initiatives, and they're sort of checking it out to see if it makes sense and if it works. Right now, when people go to court in Ontario and they ask a judge to make an order for a PC to be involved, the judges decline because under our current rules, that's considered a delegation of judicial authority, and it's prohibited for a judge to say, Judge, I'm giving Steve Benmor judicial authority over this family. Whereas in British Columbia, they amended the law to allow that to occur. Will that happen in Ontario one day? I think it will. And one of the reasons why, and this is just my analysis, not anybody else's, one of the reasons why the Family Dispute Resolution Institute of Ontario created a roster and a certification system with the necessity of insurance is so that one day, if and when there is the need for professional parenting coordinators, FIDREO can come forward and say to the government, look, we have trained, educated, and licensed or insured PCs who are ready, willing, and able to be able to accept the appointments under court orders. If we didn't have that, it would be a much harder sell for judges because the judges wouldn't have any sort of regulation and governance over PCs, whereas now we have built that into the system through FIDREO.
That makes sense. And I guess that ties in. We have a listener who's asked a couple questions. What if you cannot afford a PC and the other party is demanding one, or can a PC be court ordered, or does it have to be agreed upon by both parties, which you just kind of touched upon that.
So what I say in cases like that is, you know, whenever we talk about affordability, you know, can somebody afford X? And I say to that question, can somebody not afford X? So perfect example, couple split up 2 years ago. They have a parenting plan. They just cannot agree on whether dad can take the kids to Saudi Arabia to visit his dying mother, the children's grandmother, for 2 weeks. And so mom very correctly says, Saudi Arabia doesn't have reciprocity with Canada. I'm afraid that dad might not come back right away, might stay there for a few more months. And dad says, my mom is dying and I want my mom to see my kids before she leaves. Do they go to court for that, or do they go to a parenting coordinator? I can tell you now, I've had these cases as a lawyer, and I've taken it to court, and it's cost the clients anywhere from $5,000 to $10,000 to resolve that dispute, because they have to start a brand new motion to change under Rule 15. They have to file all the documents, and they've got to ask the court for permission to bring an emergency motion. And then if they're granted leave to bring an emergency motion, then they've got to file all their emergency motion materials. And then by then they're already $5,000 to $10,000 into it, and they still have to pay their lawyers to argue the case. Had they had a PC clause, that could have been handled for probably a couple $1,000s.
And much faster. Much
faster. So back to the question that the listener asks, what if you can't afford it? The question that I asked to the questioner is, what can you not afford? You can't afford to allow this to be an issue that finds your way with lawyers and judges in court, because that's a much worse situation, because the person that wants to go to Saudi Arabia, they're going to bring the motion, and it's going to force the other person to spend equal amounts of money on that. Whereas if they both agreed months or years in advance to have a PC involved, then it would have been a faster, cheaper, and easier route to go.
No, definitely. Well, unless you have anything further to add, I think that covers the topic for today. Thanks to our listeners for joining us, and we will be back here again next week for another edition of Divorce Explained.
Bye everybody.
Thanks for tuning in to today's episode of Divorce Explained. If you enjoyed it, don't forget to head on over to Instagram and follow at Steve Benmor and at Leanne Townsend Life for more. And if you're looking for specific divorce services, you can visit benmor.com and leannetownsend.ca. We hope today's episode made you feel informed and inspired as you move along through your divorce journey. Tune in next week for Divorce Explained.